Good afternoon. Welcome to today's webinar entitled Navigating the Brave New World of Unemployment Insurance in the Technology Age, Enforcing the Federal Laws that Guarantee Access to Benefits in the States, hosted by the National Employment Law Project, also known as NELP. My name is Rebecca Dixon. I'm a Senior Staff Attorney and Acting Deputy Program Director at NELP, and I'll be your moderator for today. We're excited that so many of you could join us. Before we get started, I want to review a few housekeeping items and let you know how you can participate in today's web event. This webinar is scheduled to last for 1 hour. Like many public benefit programs, the basic interaction of the unemployed workers seeking to access benefits has transformed with the shift of web-based technologies and phone technologies that determine how people apply and collect for benefits. While many workers are adept at navigating these systems, and they can actually expedite their claims, many workers also face challenges. We will be sharing a PowerPoint presentation covering the U.S. Department of Labor's new state guidance that clarifies state responsibilities for ensuring UI access in this time of technological change. You will also hear from a NELP expert who will discuss how you can aid in the implementation and enforcement of the new guidance in your state. In order to leave time to get your questions answered, we will do the question and answer period at the end after all presenters have spoken. To minimize background noise, all lines except those of the presenters have been muted. If you are listening through a computer and have issues with audio quality, please use the call-in number. The call-in number is 1-887-219-3817, and the passcode is 85001313. Please note there may be a slight delay as the slides advance. We will be sending you a link to the webinar recording as well as a copy of the PowerPoint after the webinar. Please type your questions into the box at any time. I will collect those and direct them to the appropriate panelists. We will try to answer as many questions as we can in the time allotted. So here is the layout for our webinar overview. I will provide you with a few slides to set the context for the guidance and for what you'll hear later. Then you'll hear from our first presenter, Gabe Gilbert, who is Administrator in the Office of Unemployment Insurance at the U.S. Department of Labor. Next, you will hear from Naomi Berry Perez, Director of the Civil Rights Center at the U.S. Department of Labor. And our last speaker will be Senior NELP Staff Attorney George Wentworth. So to give you some context for the need for this guidance and the discussion that we'll have today, in 2007, before the recession, 2.6 million workers were claiming UI benefits. But as the job losses piled up in the next few years, that number nearly quadrupled and rose to 10 million by 2010. With state expansions and federal extensions, the UI program rose to this challenge. Between 2008 and 2013, 24.5 million long-term unemployed workers received $230 billion in emergency benefits and extended benefits. States worked really hard to pay claims as quickly as possible using their outdated technology and facing numerous changes to the federal extension program that required numerous reprogramming. Under this tremendous pressure, customer service in the states sometimes broke down, and phone lines were jammed and IT systems crashed. In some cases, this made it nearly impossible for claimants to file for benefits. This really drew NELP's attention, and especially with reports from people like you in the States. And it spurred the paper that we wrote in 2013, The State of Disrepair. At its peak in 2010, 7 out of 10 of the nation's unemployed workers were receiving state or federal UI benefits. But as you can see from this slide, recipiency has now fallen to a record low, ranging from 12% in the state of Florida to 51% in North Dakota, and the U.S. average is 27%. Some of this is due to state changes in eligibility criteria, cuts to weeks in benefits and amounts. But in some states, recipiency has been affected by issues that they've had with their phone and computer technology. As you can see from this slide, unemployment is down, but first payment timeliness, which is the standard that states aspire to pay benefits 87% of their first payment benefits within 14 or 21 days, has not bounced back, even though claims have fallen. You can see from the slide that the U.S. surpassed this standard every year before the recession and has failed every year since. In the calendar year 2014, 25 states, including D.C., fell below the standard of 87%. As you can see in this state-by-state breakdown of payment timeliness, 8 states fell below 75%, including 3 states that launched modernized IT systems in 2013. All of those were below 70%. Massachusetts, Florida, and California were 3 states with new systems that are included there. As you can see from this slide, there's a mismatch in the IT that the states are operating and the demands that they have placed upon them in the 21st century. So despite the increasing reliance on phone and computers to process claims, they don't have modernized systems to process these claims with, and that would help you see some of the issues that have cropped up. As you can see, the average replacement cycle in the private sector for their IT is 5 years, but the average age of the UI benefit technology is about 25 years. So this is a screenshot of our report, The State of Disrepair, that I referred to earlier. Here's some examples of some of the challenges that states have had. As you can see from recent state audits in Tennessee, Wisconsin, and California, we see that workers are struggling to get through on the phone. In a California audit in 2013, you see that 24% of calls were blocked, meaning workers were not able to get through to ask questions to an agent. And redials were 25 to 45 times on average. Federal funding has failed to keep pace with caseloads and infrastructure needs, and some states have recently had layoffs, including Rhode Island, Connecticut, and Florida. And in 2013, newly modernized systems in California, Massachusetts, and Florida crashed. Now I'm going to turn it over to Gay Gilbert for the next presentation.
Good afternoon, everyone. It's a pleasure to be here with NELP and my colleagues from the Civil Rights Center here at the Department of Labor to talk about this most important guidance. Naomi Berry-Perez, who is the director of the Civil Rights Commission, and I have been working for some time to bring this guidance to the system with a firm conviction that it had been way too long since we had done so, and there were just many reasons why we wanted to do that. And let me just kind of walk through a couple of those. And I will say that while Rebecca has focused on technology as one of the foundational reasons, I think we think it's not just technology, although it's certainly a big one. We have increasingly diverse populations that need access. We have the whole paradigm for delivery of UI benefits has changed, and most states don't have any unemployment insurance staff in their one-stop centers. And there is no such thing as an unemployment insurance office anymore. We obviously a much increased use of online filing in many states, and particularly as they move to modernize their systems. As Rebecca pointed out, we have really antiquated IT infrastructure, so many states are either have or are in the process of modernizing their systems, and we would love to have more money to do other states, but that's a different story. Yeah. So how is it that we kind of move to ensure that we're going to have access as technology evolves? First of all, let me just say that when modernization of the IT infrastructure for UI is the most extraordinarily complex thing almost ever. From my experience in working with our consortium of states and other states who are working to do so, it's a complicated program with many moving pieces and parts. It's actually multiple programs. lots of need to interface with other databases and other programs, et cetera. So it's just very complex. And so getting to a successful modernization is hard at best. Having said that, and it is, however, an opportunity for states to improve efficiencies, to help manage shrinking resources, staff resources, and to actually get better and more accurate at the work. And I think overall we are hopeful that technology will in fact do all those positive things, but in the process we obviously need to work with states to ensure that new technologies and business processes do not create barriers that prevent access. And I guess one other thing I would say about that, we are doing lots of work with states at this point through our Information Technology Support Center to ensure that states are able to manage the complexities of their modernization projects, including offering up technical assistance around ensuring that they are providing access. So this is a big area of technical assistance for us at this point also. So what does access mean? And again, this is in the broad sense. Obviously, communications that are easy to understand by all claimants, processes for accessing benefits or filing for benefits that are also easy to understand and easy to navigate. Providing alternative methods of communication or processes to those with barriers, and we'll go a little bit more into who we think that is. And then a new one, which is under the Workforce Innovation and Opportunity Act, and it wasn't part of this guidance per se, but we do have new language in WIOA that suggests that that requires actually that in our one-stops that we are providing assistance to claimants in filing claims, and we see that as another kind of hook for us to help move states toward improved access for UI benefits. So let's talk about what kinds of communications and processes must be accessible. This is obviously not an exhaustive list and probably will change over time as new stuff happens. But obviously websites, online tools for filing and carrying out other required activities such as registering for work or reporting work search requirements. The forms, the questionnaires, the correspondence that is related to establishing eligibility and maintaining eligibility, benefit rights information, and many states vary totally across the board in how they do that. Some still do it in paper, some do it online, some do it mail a book. There's just a variety of ways that states do this. Appeal rights and appeal process is particularly important, ensuring that folks understand their due process rights. Instructions and information pertinent to filing and maintaining eligibility, we already said, and staff actually communicating. One of the things that I think we're going to be focusing on more in technical assistance as we move forward is ensuring that state staff are trained in the alternative access methodologies and that they are able to, in fact, engage with the different populations that have barriers effectively. So this guidance, this joint guidance, actually has two legal sets of authority under which it flows, and I'm going to talk mostly about the UI piece of that. So the Social Security Act, and I think many of you probably know this, gives us our wonderful statement of methods of administration is reasonably calculated to ensure full payment when due. That is the line from our statute from which much of our compliance and guidance to states flows, and this is no exception. So this issue about providing access, ensuring access to the benefits, this is the primary legal foundation. So what does that kind of mean? What we've said in our guidance, first of all individuals must have the opportunity to be informed and take appropriate actions to apply for UI, maintain their entitlement, access services without undue burdens and barriers. They have to be provided the ability to complete, submit, and obtain information about their initial and continued claims, appeals, work search, reemployment services, and any other information or functions or services available to claimants, particularly when it applies to their eligibility. And in most cases, all those things do. Technology and information systems used to administer the program must not create barriers, either procedural, technological, or informational, that prevent individuals from accessing UI program services. And while this seems very logical, this is the first time we've articulated it to our system in writing, and so we think it's been a very important message. Also, one of the core areas of kind of due process, I think that is we've opined on here too, is there is a required standard for claim determination. So when a decision is made about someone's eligibility, it requires written notice of any determination, particularly if it adversely affects an individual's right to their benefits, and it must furnish sufficient information to enable the individual to understand the determination and his or her right to protest, request reconsideration, or appeal. So as we approach this guidance again, I think we obviously wanted to focus on the protected classes, and maybe I'll talk a little bit more about that, I'm sure. And but we actually went beyond that. There are clearly individuals who face access barriers that are not necessarily the named protected classes. They may include people who are in protected classes, however. So in addition to those with disabilities or individuals with limited English proficiency or older individuals, we also have people who have the challenges to either use technology or even have it or have access to it. And then also people who have challenges with literacy, either in English or their own native languages. So these are the primary categories of people that we kind of focused in on. But again, it's any individual who has a barrier. There is a responsibility of the system to make sure they have access. So back to technology for just a minute. Some of the things that we're pushing our states to do as they are moving to modernize, obviously, is to ensure they're doing adequate testing, and that one of the challenges is that states sometimes under the push from political forces may be required to move forward a project faster than it should, and that results in inadequate testing, inadequate, in some cases, just simply getting all the pieces and parts of the system ready before it goes live. And so not only does it need to be adequate testing, it needs to be all there, and that includes the accessibility pieces. It means that staff have to be fully aware of how to use it and how to help other people use it, and claimants to use it. And then one of the other things that we've found is that some of the early states that modernized systems didn't kind of recognize that when they went live, this was going to be a massive change for the claimant population, and so their call centers would become overwhelmed, and they had not ramped up to do that, and so huge backlogs would occur, and again, it was just a spiraling cycle, which really impacted lots of claimants. So again, we're working really hard to help states understand what all those steps are that need to be taken as they are moving to a go live of a new system. Again, this is some areas where we have articulated things in writing for the first time. States may not exclusively require all claimants to file for benefits online, because we know, in fact, that there are people who cannot do that. And so that cannot be the policy of a state to have exclusive online filing. States must establish alternative methods of access, such as telephone or in-person options, and they have to be reasonably timely. Not only do they have to be there, but they have to be timely and similar to the kinds of services that they would receive otherwise. And the alternative access methods must be communicated widely and clearly, and those communications need to be targeted in ways that the populations that have barriers will in fact be able to understand them and receive them. Also, we're suggesting to that end a wide array of media to ensure the effective communication, and so here are some examples here on this slide. I won't read them to you, but obviously the communication is just really absolutely critical. So just kind of summary on this: providing access. States must establish and communicate the alternative access points. They have to train their staff, make sure that they can connect claimants to those alternative access points. And also now there has to be the ability to support claimants who need it in the one-stops, either actually physically with a person helping them, or virtually on the phone, or through other technology means such as Skype. And again, it has to be in a reasonable time period that you would that they can actually get the service that you would expect. Thanks. So going backwards. Okay, go ahead. I think this is kind of a repeat of some things I've already said, so let me go ahead and move forward. My clicker here is, and I are not, okay. So let me, let's talk a minute about the role of state CEO officers. One of the things I think we've learned over time is that in all cases, the EO officers are not necessarily as closely connected to the state UI agencies and other program offices, for that matter, as needed. So we are strongly encouraging in this guidance that our state UI agencies reach out to their EEO officers, that they engage them when they're developing strategies to support individuals with barriers. If they're moving to something like a modernized system, that they're part of the planning process. So we're really strongly encouraging a much stronger partnership. One of the things that I think we also know in issuing this guidance, and in many cases I wish we had a lot of already pre-prepared technical assistance ready to roll out at the same time the guidance came out. I will be candid to say that we aren't, but we're going to take every opportunity at this point to not only reinforce the guidance, but to develop new technical assistance strategies to support states, and we envision that to be a collaborative effort as we move forward with CRC. And obviously working with states directly. So one of the things that I was going to, as an ask of you all today, if you have thoughts about any kinds of technical assistance, and I think I lifted this from a different presentation, but if you have thoughts about the kind of technical assistance or tools and products that would be useful for us to showcase to states, I would love it if you would send them to me, to Naomi, to whoever, and we will find ways to share those back with the states. So I think that just a few end notes here. Just reminding you, this is the UI community is diverse and continually changing. I think the accessibility issue is a core value, and I think we have not reinforced that enough. And we are starting to do that with this guidance, intend to build on that. We think that technology is a good thing mostly, but it needs to be managed and utilized correctly. And obviously, enabling access is a shared responsibility for all of us, and we are most committed to doing that. So I'm going to stop there, and I'm going to turn things over to Naomi.
Thank you, Gay. And thanks to the National Employment Law Project and to all of you who are joining us on the phone today. In addition to myself, I want to introduce the other Civil Rights Center staff persons who are here with me, just because we are a small operation, and if folks attempted to reach out to me, they likely would be forwarded to the gentleman here in the room. First is Roger Ocampo. He's our Chief of Compliance and Policy. And the second is Lee Persolay, who is a Senior Policy Advisor. So again, we're grateful for this opportunity to be here with Gay Gilbert and all of you to provide some information on the guidance that we jointly issued after more time than we wish to have developed and actually disseminate that piece. And we're also grateful, speaking of dissemination, for your assistance in getting that information out to all necessary stakeholders. So my task today is to review some of the legal non-discrimination requirements as well as guidance to comply with these requirements. So Gay spoke before about some of the protected groups that we address in this guidance: individuals with disabilities, persons with limited English proficiency, older individuals, and then Gay, of course, spoke about individuals with less access to technology and perhaps individuals with lower literacy as well. I'm going to speak about the first three and give some sort of a legal framework for those protections. But we actually start with Section 188 of the Workforce Investment Act, or the Workforce Innovation and Opportunity Act. Let me say from the offset that you all probably know that the Workforce Investment Act, WIA, was sunset this past year, and the Workforce Innovation and Opportunity Act, WIOA, as we call it, took effect this year. Under both statutes, there was a Section 188 that contained the non-discrimination and equal opportunity provisions, and that Section 188 prohibits discrimination on the basis of race, color, religion, sex, national origin, age, or disability, as well as political affiliation or belief. And there are a number of other bases as well, but for the purposes of this conversation, that's a fine list. And discrimination is prohibited by recipients of WIA or WIOA Title I financial assistance, or by partners to the one-stop workforce system, including unemployment insurance. And then my next point here is that Section 121 of WIA and WIOA defines UI state agencies as required one-stop partners, so state UI programs are subject to the non-discrimination requirements of Section 188. The implementing regulations of WIA are found at 29 CFR Part 37, and there are implementing regulations under WIOA found at 29 CFR Part 38. I want to say here that the 29 CFR Part 38 was published in July as a final rule, and as the preamble to that final rule states, it was published as a placeholder to ensure that there would be no gap in coverage, but with the expectation that the Civil Rights Center, on behalf of the department, would propose a rule to update the non-discrimination and equal opportunity requirements under WIOA. I can't tell you much about that notice of proposed rulemaking, except that it went to the Office of Management and Budget almost 90 days ago. And there is an executive order that requires the Office of Management and Budget to complete its review within 90 calendar days. Now, I don't know who's enforcing that, but the point here is that we do hope, we are planning for a notice of proposed rulemaking to be issued in short order. When that specific date rolls around, we're starting a wager around here. But we ask folks to keep their eyes open for that. The notice of proposed rulemaking, of course, is just that. It's a notice of proposed rulemaking. The elements of those regulations will not be made final until after a comment period and a further review period. So at this point, the information in the guidance, and quite candidly, going forward, we believe the information in the guidance not only supports our interpretation under WIA, but will support our interpretation of these requirements under WIOA as well. So now moving specifically on to the legal requirements with regard to individuals with disabilities. Section 188 of WIA and of WIOA prohibit discrimination based on disability in programs operated and activities provided by recipients of WIA. There's too many acronyms, as is always the case in federal government. WIA and WIOA Title I financial assistance, or by one-stop partners. These regulations prohibit covered entities, either directly or through contractual, licensing, or other arrangements, from using standards, procedures, criteria, or administrative methods that have the purpose or the effect of subjecting qualified individuals with disabilities to discrimination on the basis of disability. The regulations require, for example, that a state UI agency make reasonable modifications in policies, practices, or procedures when the modifications are necessary to avoid discrimination on the basis of disability, unless making such a modification would fundamentally alter the nature of the service, program, or activity. The WIA/WIOA regulations also require that state UI programs and other covered entities take appropriate steps to ensure that communication with beneficiaries, registrants, applicants, eligible applicants and registrants, participants, applicants for employment, employees, and members of the public who are individuals with disabilities are as effective as communications with others. In addition, Section 504 of the Rehabilitation Act of 1973 prohibits discrimination against individuals with disabilities in any program or activity receiving federal financial assistance, which includes state UI programs. And Title II of the Americans with Disabilities Act prohibits public entities from discriminating against qualified individuals with disabilities or from excluding such individuals from participating in or denying the benefits of their services, programs, or activities. So a broad range of laws supporting the prohibition against discrimination, again, either in purpose or effect, with regard to individuals with disabilities. Speaking specifically about technology, of course, technology and online applications can expand access for people with disabilities, but it can also restrict access for individuals who do not have access to this technology, don't have the capacity to use the technology, or if the technology does not fully utilize accessibility options. In the federal government, we sometimes think of, there's Section 508 of the Rehabilitation Act speaks to making technology accessible for individuals with disabilities, and in the guidance we provide an appendix that speaks to how guidance under Section 508 can help entities comply in this context as well. So state UI agencies that develop then web-based systems must design them to ensure that information about services and benefits presented in those systems and the claims filing processes implemented through those systems are as accessible to people with disabilities as other individuals without disabilities. I want to highlight here where we talk about designing, both designing and implementing, and reference again GAY's guidance before about including state equal opportunity officers in all of the steps of a process. Of course, if systems are effectively designed, then we have fewer, if any, problems down the line with regard to accessibility. If systems are not accessible, states must provide reasonable accommodations and modifications, including communications options that render the services as effective as those offered to others. Moving on now to the legal requirements that support the provision of services to individuals with limited English proficiency. Title VI of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, and national origin under any program or activity receiving federal financial assistance. We don't say it on the slide here, but the Supreme Court and the Department of Justice and others have interpreted that prohibition against national origin discrimination to include services to individuals who are limited English proficient, or LEP. Section 188 of WIA and Section 188 of WIOA contain a similar provision. Executive Order 13166 also requires improved access to services for persons with limited English proficiency. So briefly, the obligations to provide services to people who are LEP are as follows. For languages used by a significant number or proportion of the population served, a recipient, including a state UI entity, must take reasonable steps to provide services and information in appropriate languages. And for less widely used languages, the recipient should make reasonable efforts to meet the particularized language needs of such persons. Again, with individuals with disabilities, although technology-based service delivery models may make access for some LEP individuals easier, web-based UI information and claims filing systems may have the effect of limiting access for LEP individuals in violation of Title VI and WIA/WIOA regulations, especially if such information and systems were not effectively designed and then translated and implemented into appropriate languages. State UI agencies that develop web-based systems should again design them to ensure that information about services and benefits provided in those systems and the claims filing processes themselves implemented through those systems contain meaningful translations of vital information into appropriate languages and are otherwise accessible to LEP individuals. As a last piece of advice on this, the guidance says that use of machine translation services such as Google Translate, those services are not recommended. At this point, technology in this area is evolving pretty rapidly and certainly would be very helpful, but at this point the reliability of machine translation services tends not to be good enough, and so they're not recommended. Agencies have an obligation to ensure the accuracy of their translations. Moving on to the legal requirements with regard to older individuals. Whenever I read this information, I think about my 84-year-old grandmother who was much more able to navigate Facebook than I ever will be. But nonetheless, statistics bear out that some older individuals may have challenges with technology, as I'll discuss in just a moment. So the Age Discrimination Act of 1975 prohibits discrimination on the basis of age in programs and activities, again receiving federal financial assistance. And Section 188 of WIA and WIOA also prohibits discrimination on the basis of age in programs operated by and activities provided by recipients of WIA, WIOA, Title I financial assistance, or by one-stop partners. A large percentage of older individuals may not possess sufficient knowledge and understanding of computers or web-based programs to be able to access information about the UI program via website or file for benefits through an online system. As a result, if a state UI agency develops a web-based system as its sole or primary method for individuals to access information and services, including filing for benefits, it may deny older individuals equal access in violation of the Age Discrimination Act, WIA, and WIOA. It is critical to ensure that alternative methods for accessing each aspect of the program are available to older individuals and that notice about these alternatives is disseminated to this population. So finally, I'm going to speak just for a few slides here about the Civil Rights Center and about the process of filing a complaint through the WIA or WIOA regulations. I'm the only person in the building who's allowed to go out and generate complaints, and I'm pretty good at my job. I wish I could hear you laugh, because I'm sure you did. So with regard to complaints, any individual who believes that they have been or are being subjected to discrimination prohibited by Section 188 may file a written complaint locally with the recipient or with the Civil Rights Center. Again, that's or. Locally with the recipient or with the Civil Rights Center. Each state must adopt and publish procedures for processing complaints that allege discrimination by any WIA or WIOA recipient. The governor, the local workforce investment area, and equal opportunity officers are responsible for developing and publishing complaint processing procedures. As Gay mentioned, the equal opportunity officer is responsible for ensuring that WIA, WIOA recipients follow procedures for processing discrimination complaints. So it's particularly important that they're aware of the systems being operated within their states, and that they are able to navigate those systems themselves with regard to enforcing this rule. The procedures must provide the complainant with the option to file it with the recipient or directly with the CRC. Complaints can be filed by an individual, by one or more similarly situated individuals on behalf of themselves or others, or by a third party, such as an advocacy group, on behalf of others. Complaints must be filed within 180 days of the alleged discrimination, And recipients must issue, recipients being the state or local entity or service provider that receives the federal financial assistance, must issue a written notice of final action on discrimination complaints within 90 days of the date on which the complaint was filed, and must include notice that the complainant has the right to file a complaint with CRC within 30 days if dissatisfied with the recipient's final action. So again, at this time, the procedure calls for the ability to file locally or with the Civil Rights Center. If an individual chooses to file locally, they then still are given, they're not appeal rights, but given the right to then thereafter file with the Civil Rights Center again. So that is the information I wanted to share with you today. Again, information on some of the legal requirements, and then ways in which to alert the CRC to concerns, particularly under the non-discrimination equal opportunity provisions. But you know, I'll just close by saying this guidance was issued jointly with UI, and and we're working cooperatively. We have been working cooperatively for a number of years now. So any concerns that are brought to our attention or brought to GAY's attention on these issues, we will continue to work together to arrive at an outcome that is mutually satisfactory. Thanks very much for the opportunity. I think I'm now passing to George Wentworth of NELP.
Thanks, Naomi. This is George Wentworth. As a lot of you know, system access has become sort of the great civil rights challenge for UI advocates. What I'm going to talk about today is more of a practical look at what's going on in the states from the perspective of advocates, including many of you who are on the call. I want to talk a bit about the program letter 216, which is really a very groundbreaking document. Some of the access issues that we have seen out in the field with our advocates, focus on one particular state that's had some big problems, and then finally talk a little bit about how you can and should work with your state UI agencies to build better systems. As Rebecca alluded to, we start in a pretty bad place. Before the recession, recipiency nationwide was about 36%. It went up to about 68% at the peak of all the extensions. After EUC went away, we are now looking at nationwide recipiency of 27%. So there's a quarter less claimants receiving benefits today than there were at a comparable unemployment rate before the recession. So the states are dealing with a lot of resource constraints, but the trend is out there. Currently, about a third of all states are in the process of modernizing their benefit systems. About another dozen have already made some effort at a modernization. And generally what you're talking about is a modernizing state is probably taking the majority of its initial claims by telephone. A few still maybe in person, but it's mostly call center operations, and then they're taking their weekly claims online and by telephone through an IVR technology. And because there are limited resources for call center staff, most states that modernize are have a goal of trying to get the largest number of claimants filing their initial claims online. And it's that percentage of individuals who cannot file online that we're really talking about today. And the challenge for the state is to make sure that they have an alternate filing mechanism that's available to those claimants who need it, as you've heard. Just in terms of research out there on the digital divide, the Pew Center did a survey a couple of years ago on internet usage that really raises some issues about the impact of relying too much on online filing systems. You can see some of the data here. 15% of American adults don't use the internet. 44% of those over 65 don't use the internet. About a quarter of Hispanic Americans do not use the internet. The most common reason is for not using the internet is cost, which of course is what our clients are all about. They're unemployed. Internet is often something that is a luxury for unemployed Americans. So as you've heard, what are the groups we're talking about? We're talking about LEP claimants, those with literacy challenges, those with physical or mental disabilities, and then this broader category which encompasses some older workers, but not just older workers. These are individuals who just have limited experience with computers or limited fluency, or maybe don't have physical ready access to computers, although I think that's a secondary problem. And I want to say, just from the advocacy work we've done, that there really is another category here, which is not so much a protected class, but depending on the state system you're dealing with, we have had lots of experiences with people who are fully educated, would seem to have an average level of computer literacy, who struggle with online filing with some systems that are too complex in their design. So Naomi went through the various legal bases for protections here. The familiar one to the UI community, Section 303A1 of the Social Security Act, which is the when due clause. States have to have such methods of administration as are found by the Secretary to be reasonably calculated to ensure full payment of UI when due. And we're familiar with that largely because how it relates to the timeliness of benefits. So what's really groundbreaking about this UI program letter is this language in bold here, is that where the concept of methods of administration calculated to ensure benefits when due now it definitely means that states have to ensure that new technologies and systems for administering UI programs don't create barriers, procedural, technological, or informational, that may prevent individuals from accessing UI benefits, such as by denying them a reasonable opportunity to establish eligibility. This is right from the program letter, and it may seem obvious to us, but it was written nowhere before this program letter that was issued on October 1st. This is important because this applies to everybody, not just protected classes. Everybody, the Social Security Act requires the states to make sure that technology doesn't block the door to unemployment insurance eligibility for those who are truly eligible. Naomi went through the various protections. I've got them listed again here on this slide. So what are the common problems that we're seeing out there? Amongst the most obvious, some of the states that have modernized their systems, their online applications are not translated into those languages that they're required to be translated into the state significant LEP populations. States that are sending non-English speaking claimants to an alternate mechanism, that is a telephone with an interpreter who's either going to assist in the completion of the application or take the application, that there are, there's either a lack of interpreters in certain languages or big delays in access to getting to them. Some states to date have not had alternative filing mechanisms at all. And then I've got kind of a secondary question here, which is, I caution advocates from thinking about this solely from the point of protected classes, because, as I said, I think 303 in the Social Security Act really guarantees it as a fundamental right. But since states are pushing hard to put everybody, to get as many people to file online as possible, there really are issues about how you identify which claimants should be offered the alternate filing mechanism. How do you determine whether it's too hard for the claimant to complete online? Should it just be a matter of individual preference? One of the things we've seen is sometimes these online filing systems are also coming at the same time as other integrity initiatives and new filing requirements that weren't necessarily the case when someone was filing in person or through the call center. So amongst the things we're seeing are new requirements to complete online registrations for employment service. May not seem so bad, but if you've got to navigate a fairly complex online transaction after you've completed your initial claim, some of these are requiring the submission of online searchable resumes. For some of our clients, this is a lot to do with, especially if there's not a lot of assistance being provided. In addition, we're seeing a number of states going that have had work search requirements all along, now requiring online submission of detailed documentation of multiple employer contacts with sometimes 3, 4, 5, 6 pieces of information per work search. Some troubling trends we've seen in some of the systems that have gone up recently, the overly complex issue-driven systems that require much more adjudication in order to release payment. These all go to access because there's more and more transactions that are generally need to be completed online. So we're seeing instances where there's many more adjudications being done with respect to an individual claim. One state system, newly designed system, generated 140 separate claimant questionnaires around initial eligibility, and in their first year they saw almost 1,000% increase in the number of adjudications they did related to the non-separation issues. So a lot of online filing instructions presume a pretty high level reading level or sometimes an understanding of UI jargon. Some states, as we've said, are not fully considering in the design phase what their obligations are under Title VI. Some states to date have tried to limit initial claim filing to online only. That's now clearly prohibited by the new program letter. The other issue is publicizing those alternative filing methods. We've got some examples here of some of the problems that come with substandard alternate filing mechanisms, either being poorly publicized, phone assistance limited to just answering questions but not actually taking the application. Sometimes a new online system goes up, there's a substantial cutback in call center assistance so that there's longer waits, busy signals. Use of agency computers is available in the one-stops, but there's not necessarily any staff assistance to complete the claim. These are sort of examples of some of the things that make the alternate filing mechanism somewhat substandard. We just did a report on Florida. They went to an online-only filing system in 2011. It resulted in very difficult for claimants to use. Initial claims fell 23% in the first year, even though they only fell 9% nationally. First payments fell 41%, even though they only fell 10% nationally, and the economy was roughly trailed the national. So there were Florida Legal Services filed a claim with the Civil Rights Center, which has issued a preliminary ruling that these practices discriminated against the disabled and LEP claimants. NELP also was involved in filing a complaint. We just did a more recent report called Ain't No Sunshine, which really tracks the more recent system that they put in 2013 that has really had a dramatic impact on recipiency. They went from 16% to 12% in 1 year, and the percentage of claimants who are actually receiving benefits in Florida now is down to 39% compared to a national average of 68%. So you can see that in this graph. I think we've talked about the LEP, the legal basis for protection. Some of the concerns we have, web-based claim filing systems that are only in English, and some states are basically building their Spanish or other language systems after the fact. Telephone wait times for the alternate systems can be long. I would just say for advocates, what we say is ascertain your state's UI modernization plans and what their current system is. Reach out to this equal opportunity officer who handles discrimination complaints, but also provides input into the design and operation of UI systems, and offer to provide the perspective of clients and constituencies in the planning and design of new systems, or in problems that are occurring with existing systems. Focus on legal compliance for protected groups, but look at the broader principles in the program letter, which guard against excessive complexity and readability issues. Again, this is particularly important around the launch and immediate post-implementation of a new system. We offer an example here of kinds of the things you should be doing using DOL data to track, make sure that when a new requirement goes in that there isn't a spike in particular kinds of disqualifications. And Naomi has talked about complaints and remedies. I realize we're going long, so I appreciate everyone's patience, and I'm going to turn it back to Rebecca.
So we'll now begin our question and answer period. If you have not already done so, please type your questions into the box. And we are a little bit behind time, but we won't be cut off, so we can go a little bit over and try to get some of these questions answered if folks can stay on and bear with us. So the first question I have is, are states required to give reports to USDOL on the ways in which they are implementing UIPL 216? And I guess that's for you, Gabe.
Sure. Actually, no, we currently don't have an information collection that's designed specifically for that. However, I think if we learn that states are having issues, we are likely to require them to have, as part of our monitoring and oversight, to have them do corrective action plans that we would then follow up on and help provide technical assistance to them to make the appropriate changes.
In the equal opportunity, the Section 188 requirements, there is currently a requirement for something called a methods of administration, where we ask the states to inform us how they are implementing the equal opportunity non-discrimination regulations. So that's a kind of a proactive thing, how they're doing it, not how they have done it. So we get some of that information in those reports.
Okay, thank you for that.
I would also say, one of the things we are doing is when states are implementing new technology now, we are about to require a report about 6 months or so out from go live that they have followed all the pre-implementation planning steps, and that includes providing the appropriate access.
Okay. That's very good information for everyone out there to have. Another question is, could DOL recommend or require that states provide, quote, unquote, good cause provisions for any failure to comply or late compliance with program requirements or late filing of appeals for claimants whose failure to comply is due to one of these various barriers, literacy, computer access, disabilities, etc.?
I'm not sure I fully understand that.
I think what they're saying is that if somebody fails to comply, say they don't get their benefits filed on time, or they miss a week, or they miss the appeal deadline because of an access issue with language or one of these other issues, is there a requirement that this is good cause?
So I don't know that there's a flat-out answer to this. This is almost a situation-by-situation issue. But certainly when we've had situations where claimants have been, in some cases, claimants have been impacted by these kinds of situations. We have actively worked with the state to go back and make the necessary, take the appropriate corrective action in that situation, and that may include going back and redetermining cases or other kinds of things. So,
I'll just add to that our process is one of neutral investigation and adjudication. So there are some occasions where we'll see something come in, a complaint come in, and it'll look on its face to have some concerns, and I'll reiterate what Gay said. We'll contact Gay's office, and Gay's office will help us contact the state and attempt to provide some remedies if those allegations are verified in short order, provide remedies as quickly as possible. There are, however, situations where the evidence is not as clear, and so we are going to conduct an appropriate investigation and then follow the complaint processing procedures that are included in our regulations. This often, unfortunately, means that decisions are not rendered until later in the process. But again, we do see complaints, of course, that are meritorious, but we see plenty of complaints that cannot be substantiated under the law.
Yeah, I would just like to add to this. Well, I don't see a federal requirement on this. Most states will have good cause provisions related to late filing of appeals and late filing of claims and other required actions. And good cause definitions typically subsume failure of the agency to comply with its own procedures. I would say that any advocate who's got a claimant who didn't do something they were supposed to do because they couldn't get through the system, and that can be, days of busy signals, or it can be an automated program that isn't allowing you to complete the transaction in the week that it's supposed to happen. They ought to be raising the program letter 216 as evidence of what the state's required procedures ought to include. And so I do think while there's not I don't see a federal change in good cause. I do think this document goes a long way towards spelling out what the state's obligations are.
Okay, and then here's another question. What are the remedies available to those who file a Section 188 complaint?
So generally the remedies are include make whole relief, so putting the person in the situation they would have been absent the discrimination. So in the case of UI, it's getting the person typically with regard to access, it's making sure the system is then accessible so they can go through the system, and if they are then eligible for the benefits, they will receive the benefits retroactively, and I believe with interest, but don't hold me to that. My lawyers are not in the room. I will say, so it's a make whole, it's generally a make whole approach. We are very concerned about not only the specific individuals who have been impacted, but about the system, the procedures and processes that cause that violation, if you will. So we are also going to look to changing those policies, disseminating the policies, making sure staff is trained, doing outreach to appropriate communities, ensuring that things are translated, technology is updated, et cetera, so that that we're remedying the specific individual, but then the situation is we're not then just waiting for the next complaint to come in the door. So that's generally the approach.
Okay. Any other responses? Okay. The next question is for you, Gay. As the discussion demonstrates the key need for modernization resources, they were wondering, are there any federal administrative funding increases that will be available for technology or to implement these?
I will tell you that in the 16 budget, we did ask for $60 million, which is not nearly enough, actually, to help us continue to advance states in their modernization efforts. we were quite lucky during the recession because this workload dropped a little faster than we anticipated, to have some extra money to put towards state consortia development of modernized systems. Unfortunately, in good economies, we're much better at projecting money that we're going to have, and so having extra dollars is not as likely. As you know, we don't have a 2016 budget yet. It's a tight budget environment. I would probably be surprised if we got that funding, but we obviously have our fingers crossed because it continues to be a huge need.
Okay, and the next question, they want to know, can we provide an example of states where an advocacy group has collaborated with a UI agency to enhance access for a group of persons with disabilities and or persons with LEP issues?
Yeah, I can take that one. In my experience, the state that I have seen that has done the most proactive work with their UI agency is Massachusetts. There is a group of legal services and other community advocates that form the Mass Employment Rights Coalition, I believe, and they were spearheaded largely by Greater Boston Legal Services and some other organizations. People like Monica Hallis, Brian Flynn, Margaret Monsell, all got very down in the weeds with the agency in trying to offer input around a lot of the design work that before their system went up. Unfortunately, I mean, there were still many problems. Their advocacy and negotiation with the agency continued for a good year after it launched in the summer of 2013. But yeah, I mean, a lot of the things they were doing was reviewing forms, saying this isn't, there's too much jargon here, this isn't readable enough. These kinds of things are going to be too complex for a lot of our low-wage workers. They did a lot of pushing for other, for the state to meet its LEP obligations, and again, they did it against the backdrop in which, the policies in Program Letter 216 were not out there. So, but Massachusetts is a state, I would say, for advocates who are looking for, a bit of a template on how to work with their agency. I would recommend turning to Massachusetts.
Okay. Any other responses from the panel?
No, this is Kay. I concur with George's suggestion. I think Massachusetts was a good example.
Okay, and then we have a question here about what kind of timeline in terms of after a complaint is filed with CRC, they wanted to know about how long does it take to get a determination.
So it depends. It depends really on the complaint, on the expansiveness of the complaint, on the other complaints kind of on the docket at the period of time. The facts are the facts. This is a very small shop. We're only located here in Washington, D.C. But our handling complaint, we have a triage process to identify priority complaints, and so our handling complaints pursuant to that process. But actually our regulations require not only that neutral investigation that I spoke about earlier, but then efforts to informally resolve a complaint. So we have been much more, we've been trying to help entities understand their responsibilities and help them identify the appropriate steps that they have to take to come into compliance, and are walking down that path. So it depends on the dynamics of that relationship with that entity.
Okay, and then this is our last question because we are over time. We have a question, what is the statutory or regulatory source for states to designate an EEO officer?
I'm looking at my folks here. I don't remember the specific provision, but it is within the Section 188 of WIA and Section 188 of WIOA. I want to say it falls in like the 37, I don't know. I was trying to pull it up. 30, yeah. It isn't within the non-discrimination provisions. If you want the specific site, we can pass that on.
Okay, and if you pass that on to us, we'll pass that on to them when we send out the PowerPoint. Is there any other response?
I'm sorry, my senior policy advisor pulled out his reg book. It's either Part 37.23 through .29 or Part 38, .23 through 29.
Wow, fantastic.
Yep, he's good.
So that's our last question. I wanted to just reiterate a few points. We will send a recording of the webinar and the slides to everyone who registered. It may take a couple of days to get those to you, but we'll get those to you. If you have questions that didn't get answered, some of the questions that came in were not really related to the webinar topics, but we'll try to get you some help with those. You can send those to me separately at rdixon@nelp.org. And also, if you have questions that you didn't get a chance to answer, you can send those to me, and I'll try to get you an answer as well. We really do thank you for your time today, and this concludes our webinar. Thank you for your time and participation.